I see our next speakers fast and furiously coming down the stairs. We've got Adam Wagman and Eric Grossman, who are going to be talking on the topic when all else fails, funding through litigation or dispute resolution. Adam Wagman is the managing partner at Howie, Sachs & Henry. He was admitted to the Law Society of Upper Canada in 1996. He's a member of the Canadian Ontario Bar Associations, the Advocate Society, and he was elected to the Board of Directors in 2008 of the Ontario Trial Lawyers Association. Adam was president of the Ontario Association of Community-Based Boards for Acquired Brain Injury Services and spent 10 years on the Board of Directors of Peel Halton Acquired Brain Injury Services. He was one of the founding members of the Board of Directors of the Brain Injury Society of Toronto. In 2010 and 2011, Adam was included in the Lexpert Directory as a leading practitioner in personal injury law. His practice is devoted to personal injury litigation, accident benefits claims, and other disability and insurance litigation. Eric Grossman is a partner at Zarek, Taylor, Grossman, Hanrahan. He was called to the bar in 1989 and was certified as a specialist in civil litigation by the Law Society of Upper Canada in 1999. Eric has been recognized by Lexpert as a leading practitioner in personal injury law. He has been awarded a BV Distinguished Peer Rating by Martindale-Hubbell for 14 consecutive years. His entire legal career has been spent acting for insurers in litigation matters, both in defense and in subrogation matters. Eric is a founding partner of Zarek, Taylor, Grossman, Hanrahan. He speaks at a number of these types of seminars and conferences on personal injury on behalf of the Advocate Society, the Bar Association, Metropolitan Toronto Lawyers Association, as well as Osgoode Hall Law School and others. He is the past chair of the Bar Dispute Resolution Group Forum of the Financial Services Commission of Ontario. He is also a past chair of the Accident Benefits section of the Canadian Defence Lawyers Organization and has been called upon to make submissions to the government on various contemplated and draft legislative changes and continues to do so when invited. So maybe we can blame Eric a little bit for the changes that have occurred. I don't know. Maybe I'm speaking out of turn.
Just because they invite me to make submissions, it doesn't mean they listen to me when I do them.
Why would they bother? Which segues nicely into the beginning of our topic, which is the basis of at least the legal portion of the crowd here getting some professionalism credits towards the CLE requirements that we all now have. The fact that you listen to Eric and I talk and that gives you professionalism credits means two things. Number one, we are going to do our best not to call each other names for the next half an hour. And number two, the Law Society has gone completely mad. And I also noticed that we're up just before the coffee break, which is, of course, cruel and unusual punishment for all of you. So we'll try and talk fast and get you out for a little break and then come back and we'll all have a panel discussion and answer some questions and have a nice discussion. So we're going to do this a little bit more free-flowing than perhaps some of the previous speakers have been, simply because that's our nature and Eric refused to practice and make any notes or anything.
This allows us to heckle each other as we go along. It's much more fun this way.
Exactly. So, we want to cover a couple of topics over the next, 25 minutes, something like that. And we're mindful of the fact that this is a mixed crowd. And so, we've got lawyers, we've got treatment providers. And so talking about professionalism and where those things overlap for this crowd is a bit of a challenge. But one of the things that we all have to deal with, or potentially have to deal with, is treatment providers, assessors, rehab people as witnesses, and how we deal with them in court, how we prepare them. And so I'm going to just start by asking Eric, what are the types of things that you see from either treatment providers or from experts retained for the purposes of assessments that get those witnesses into trouble in court or at arbitration, or, and how do you deal with that as counsel?
Well, there's lots of things that can get people into trouble, as I think everyone appreciates. A standard cross-examination of any expert could be Dr. so-and-so or OT so-and-so or physiotherapist so-and-so. You've been commissioned to prepare a report in this case, yes. You do get commissioned from time to time to do reports, yes. And yet you rarely get called to give evidence at a trial or at an arbitration. Is that right? Yes. So would you agree that, statistically 95, 97, 98% of the cases that you are involved in resolve before you have to appear? Yes, that's probably true. And you rarely come to testify, yes. And that means that people rely on your reports to get cases resolved before having to get here. Yes, and that means that you have to make sure that you're accurate, because you don't know that you're going to be called upon to actually back up what you're here to say. And obviously it's in your best interest to tell things accurately and completely because people are relying on it. Yes, and when you do get called upon, you anticipate that what you're going to be asked is going to verify that you were accurate and complete in your report. Isn't that right? Yes. And then you go about showing them all of the things that they were sloppy about, that they misstated, that was inaccurately described. And it provides a little bit more power, I think, to that inaccuracy, because everyone does make mistakes. So that is one thing that you typically do, and I think it reminds everyone that you're doing a report, you're assessing somebody, but there may be a day where you do get called upon on the carpet and that shining light is brightly in your eyes, and you have to answer for it. And I think people do these reports so routinely now that they lose sight of that, and that is a real concern. I'll give you a story, an anecdote of one of my horror shows that I had a few years ago. I went to prepare a witness to give evidence at a hearing, at an arbitration, and the witness was a doctor, and I wanted to go over the content of his report and understand how he came to the conclusions that he did, and it was in respect of a catastrophic impairment finding. And it had to do with the AMA Guides, 4th edition. And I started asking him questions about how he came to certain conclusions about the AMA Guides 4th edition, and his answer was, "Oh, I don't know anything about the AMA Guides 4th edition." And I said, "Well, that's in the report." And he said, "Yeah, it's not in my draft report. I gave the draft report to the facility that I was retained by, and the coordinator said, 'Oh, I'll help you out because I know the 4th edition and I'll fill in that part for you.'" And I said, "But your name's on the report." "Yeah, well, the coordinator told me the stuff was right, so who am I to argue with her?" And I said, "All right, I don't imagine I'm going to need to spend much more time preparing this case with you, doctor, because I doubt that I'm going to call you." Funny, maybe it's a coincidence, Adam, I'm not sure, but you haven't read about that case, have you?
No, I don't recall reading about that case.
Yeah, I don't think it actually ever went to hearing.
Yeah, it's exactly, hence why 98% of cases settle. What you just talked about actually raised a number of important issues for me that I deal with all the time, and I try and prepare witnesses for, things that lawyers might want to keep in mind, things that witnesses might want to keep in mind. A lot of cross-examinations begin in exactly the way that Eric just described. It's what I call kind of the yes run, where, as a good advocate, you don't want to start arguing with your witness at the beginning. You want to get the easy stuff out of the way. You want them to agree on you tried to be fair. You wanted all the information available to you. All of those easy questions where if anyone says no, well, they're a moron, and you just kind of roll your eyes, you look at the judge, everyone has a chuckle, and who cares what happens next because they're useless. So for the lawyers out there in the crowd, it really is good practice to make sure, even in the most hostile situation, unless you just have absolutely no reason to get anything useful out of this witness, and you just want to show how biased they are, what an advocate they are, always start with the easy stuff and start with the lessons. And for all the witnesses out there in the audience, be careful of getting into that habit of just saying yes. Because it's amazing how you can...
Except when I'm asking.
Right, exactly. Yes, Mr. Grossman, Mr. Wagman is correct, right? So that's fine. Because what can happen is, as you're on the stand, you're nervous. And most witnesses, I bet you, most people in this audience have, if you've given evidence, it's once or twice, and probably crapping yourself the whole time. The reality is that it's tense, and you want to get out there, you want to get out of there as quickly as possible, and sometimes people feel like the easiest way of doing that is just to agree. Well, be very careful, because they get the easy stuff out, and then you very slowly start to get into the more controversial stuff, and it goes from being yes, 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 yes. Well, if you don't mean yes, don't say yes. You are the expert up there. You're the one with the degree, not us, as much as we think we know what we're talking about. The reality is, the experts out there are really the experts. So hold your ground. Don't say yes when you don't mean yes. The other thing that Eric was dealing with in briefing this witness, and that we deal with all the time, is a witness that gives you a report that you think is really helpful, and then when push comes to shove, and it's time to testify, they start to back down on you a little bit. And as a lawyer, you've got to understand that a lot of what's going on there is the witness doesn't want to come testify. They're scared, they're out of their element, and they have other things that they want to be doing. And, I try not to let these...
Like root canal.
Yeah, exactly. Yes, exactly. So, what I find is, don't let people off the hook that easily. They're going to do whatever they can to try and get out of there. But when push comes to shove, when you tell them, look, this case is going to trial, you did a report, your evidence is crucially important, the reason we're going to court is because Mr. Grossman is being totally unreasonable about trying to resolve this case. If I could resolve it, I certainly would, and my client certainly doesn't want to be there, but God, we need your help, and we need you to come and support your report. When push comes to shove and they get on the stand, they will generally, pride will come into play, and they'll want to support what they've had to say.
The issue that often comes up, and it's, people are guided by the easiest route, and it's not easy to make yourself available to testify. You've got a calendar that's full. You're booking assessments 3, 4, 6 months in advance. How do you tell that person who's been waiting that many months that you can't be there because you've been called to testify? How do you account for the very helpful request made by Adam or I that, yes, we need you to testify. It could be Tuesday, could be Wednesday, could be Thursday, could be 9 a.m., could be 11 a.m., could be 2 p.m. Just, roll with it. That's the reality that trials really involve, and those that have testified frequently become a little bit more adept at dealing with it, but those that have written a number of reports that, maybe they've started writing reports 3 years ago and they've written hundreds since, well, those reports are only now starting to get through the system to call upon you to testify, and this may be the first time you're called upon, and it's like, I'm not going, I can't make it, that's ridiculous. And so the discussion that you often have is, that X hundred or thousands of dollars you charge for that report, and the X hundred or thousands of dollars that you've charged for every report since, well, that invoice has an unspoken understanding attached to it, and that is that you will be there to back it up when the time comes. And if you can't or won't, you will never be able to render another one in your entire lives. And that's the reality.
It's bad business. You also talked a little bit earlier about draft reports.
Yes.
Give me your thoughts about draft reports. I think some of the crowd might want to hear about that.
I don't like them.
Me neither.
There's a subtle distinction